Hi, I'm Dave Steinfeld. I own the law office of David Steinfeld and I'm a certified expert in Florida business litigation law. This is a video for real estate brokers on what they can do to keep their commissions. Now, this video is not intended to provide you with any legal advice. For that, you can contact me through davidsteinfeld.com. And while you're there, please take a look at the other videos and articles on Florida business law and other topics. Thanks for watching. For brokers, how do you keep your commissions? What does a broker need to do? There are two common scenarios that we often see litigated in court in these types of situations. First, there's no closing that occurs. So then the broker is not paid the commission during the time that the broker has a contract, such as an exclusive listing agreement. Or there is a post-closing refusal to pay the commission. Now, in the first scenario, I'm going to give you some like a little fact pattern here so you can kind of gauge it in your own mind. Usually you'll have a real estate broker and they'll enter into an exclusive listing agreement on a particular property. That's not uncommon. Let's say that that exclusive listing agreement lasts for 6 months. What will wind up happening is the broker will get a buyer, such as me. I'm the buyer. They'll show me the property and they'll say, do you want to buy this property? And I'll say, no, not interested, thank you very much. And I'll wait until that 6 months on the brokerage agreement, on the exclusive listing agreement expires. And then on my own, I'll go to the seller and I'll say, hi, remember me? I want to buy your house now. And we don't have to deal with the broker because the contract expired, so we can save the money on that commission. What does the broker then do to ensure that the broker can go back and capture that commission to which the broker was otherwise entitled? Documentation. It's very, very easy nowadays in the electronic world that we live in, where we're using cell phones and tablets and other devices like that to document your meetings with people on a calendar, to send emails. The key for the broker is to prove that the broker was what we call the procuring cause of that transaction, meaning that but for the broker, that buyer never would have met the seller. But the broker needs to be able to document that and to show to a court, either to a judge or to a jury, that the broker was the one that brought them to see the property, they had emails exchanged, and then when the listing agreement expired, they didn't renew it, and then we have the ability to get all the other exchanges between that buyer and seller, and then you start seeing the emails after that agreement saying, by the way, I'm now interested in buying your property, and since we let that contract expire, we can save the 6% commission for the broker. So brokers need to protect themselves by documenting the parties that they bring out to see the property. The other scenario is where there would be some sort of refusal to pay a commission post-closing. And there's a whole host of scenarios that can lead to that, but the key is for the broker to be able to move quickly before the money is dispersed in order to secure that commission. And the way that a broker does that is to consult with counsel. In the commercial sector, a little bit different than a residential broker, the commercial broker has a specific lien that's allowed to them for their commission under Chapter 475 of the Florida Statutes. It's called a broker's lien, appropriately, for the commission. But just like in construction law, there has to be notice given. So therefore, before the money is dispersed in the closing, the commercial broker needs to, with counsel, react quickly and file and record the proper notice, which is a commercial commission notice, to owner. That needs to be recorded in the public records. It's not a lien against the property. It's a lien against the monies, so you need to react very quickly before that money is dispersed. One of the other items that's important for commercial brokers to deal with is to know who's on the contract. Because if the commercial broker gets into the situation where they're going to have to file the commercial commission notice to the owner, It's the name of the broker that's on that contract that has the lien right. Brokers oftentimes work for brokerage agencies. If the commission agreement is in the name of the agency, the broker, the individual person, the broker, may not have that lien right. It goes back to the agency. So that's where the broker has to be aware of whose name is on the contract. Is it the individual broker? Is it the brokerage agency? Who's got that lien right that they can activate in order to pursue that?